Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hard-working Americans and their families?
You will! This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefits in your benefit plan. Now prepare to learn,
Plan,
save,
and protect with the FIA Group.
Hello, everyone. Thank you so much for joining us today for another episode of our Empowering Plans podcast. My name is Jen McCormick, and I am here with Nick Bonds to talk to you about a particularly important issue. And we have seen, and we've been hearing through litigation, through the news, that there is a ton of discussion about mental health. Mental health is on the rise when it comes to the issues that we're starting to see, and it is very important that we talk about the access and the opportunity to care and treatment for some of these mental health and substance use disorder treatments. And as a result of some recent litigation, which we hope to spend some time talking through today, in particular, it's the Eric versus HHS case. The heart of that case is this debate about whether some of these new regulations about mental health parity are going to apply to help enforce parity and increase access, or whether or not potentially these regulations instead are creating some roadblocks and prohibiting some progress to some mental health. And really hoping to dive into what it means for the employers, talk about this case from an overview level, what the mental health parity rules and regulations really mean, what we have seen as they have progressed and changed over the past few years or so, and in particular, what this means for employers and plans. What are the broader implications? I think there's a lot for us to consider here, not only what it means for this particular industry, the self-funded industry, but more specifically for the members and for the patients who are trying to access some of these benefits. So I know that there is a lot to unpack here, and hopefully we can really dig into this and talk about this case in some greater detail. So interestingly, Nick, I think that this case being filed on Friday, the 17th of 2025 is interesting from a timing perspective. And since this case has been filed, there has been a change in the administration. And I think some of those nuances will maybe play into some of this discussion too about what we can forecast, what we can predict, and what's going to happen on a going forward basis. But who is Eric? I think that was my first question. Eric is the ERISA Industry Committee, and they're the ones that have filed. We'll talk a little bit more about this group in particular, but they filed this suit in the U.S. District Court for the District of Columbia, and they are challenging the final 2024 mental health parity regulations. Those had been published by the Department of Labor, the Department of Treasury, and HHS. We're going to call those the departments. And a lot of specific allegations as part of this lawsuit. And Nick, maybe I'll turn it over to you to dig in a little bit about these allegations, where they're really sort of saying here that these departments sort of exceeded their authority to act in issuing this guidance.
Yeah, thanks, Jen. Yeah, so I think kind of one of the big pieces of groundwork that we need to lay is really the kind of basis that Eric, this ERISA Industry Committee, is bringing their suit under. I, in law school, was a particular nerd in that I really loved admin law. And one of the key parts of admin law is the Administrative Procedure Act, the APA. And it's sort of the handbook for how to pass federal regulations. So essentially, any regulatory agency or the federal government, they're basically in charge of enforcing statutes that are passed by Congress. And to do that, they have to go through the Administrative Procedure Act's process for crafting a rule, which means they have to, publish a draft version of the rule. They have to take a notice and comment period and collect feedback from the people in the industry or in the aspect of society that they're regulating. Then they have to finalize those rules. And it's meant to make the rule-making process more transparent, make it more collaborative in a way. And essentially, any rules that are promulgated by a federal agency that don't follow that process will be challenged for, running afoul of the APA. That's basically the standard complaint of any federal rulemaking. That's how these rules get challenged. So Eric is basically asking the DC District Court to invalidate this new set of final rules that the department's put out on mental health parity. These are the rules from last, I think September is when these were published. And they're challenging them now, basically saying that the departments overstepped their authority in publishing the rules, that the rule itself violated the Administrative Procedure Act. And now, in the wake of one of the big Supreme Court cases we spent a lot of last year talking about, the Loper-Bright decision, that threw out what was known as Chevron deference, which basically meant that a court, when it was interpreting whether a rule that was promulgated by an agency, when the court was interpreting whether that rule was permissible or not, it basically asked whether the agency made a reasonable interpretation of the statute it was trying to enforce. Now that Loper-Bright got rid of Chevron deference, the court doesn't ask that question anymore. Now the court basically asks, was the agency's interpretation the best interpretation of that regulation, of that statute in creating the regulation? So it is really kind of a perfect storm of things coming together, with the Loper-Bright decision getting rid of Chevron deference, making all administrative actions much more vulnerable to challenges, and with the new administration taking the helm of the federal government. There's just a lot of different things kind of arrayed against these final rules for the mental health parity regs. So it's going to be one of the first really big cases we're seeing testing the post-Chevron landscape of regulatory action. So I think that's a big part of what we're looking to see how this kind of shakes out. That and just, these rules are important rules in their own right. So I think there's a lot of layers to this that we're trying to sort of parse. But to talk more about, the ERISA Industry Committee, they're a national association. Their whole reason for being is to advocate on behalf of large employers who are trying to provide health and retirement benefits for their employees. And their stated goal is literally just reducing regulation, because in their view, heavier regulation is more onerous on the employers, makes it harder for them to provide those benefits. So they're basically stepping in to try to challenge the departments trying to publish those regulations. I don't know, Jen, if you wanted to dive a little more into the departments themselves and some of the stuff going on at Capitol Hill today.
It's interesting, Nick, and I think that you're onto something here about the change in the landscape here. But one of the things that I think that is interesting, if we can quickly tangent to and then come back, is that you were talking about the goal of ERIC and how, as part of this association, is that they're looking for ways to minimize the burdens that are placed upon plan sponsors who are working through this. And I think part of the argument here is that these requirements, which we'll get to in a bit for the mental health parity rules, what they are exactly, they're placing these burdens upon plan sponsors from a time perspective, and all of those who are involved in this particular process of completing the requirements and complying with the requirements of the Mental Health Parity Act, but more specifically the NQTL requirement from the CAA, that this is leading to increased compliance costs. But just a few weeks ago, there was the Mental Health Parity Report to Congress that had been published. And in talking and reading through that, it is a lengthy 140 so page document outlining some of the findings. And one of the things that they noted in this particular report, when we're pivoting back to cost here, is that ERIC is alleging that to comply is creating increased costs. But we're seeing that one of the biggest barriers to individuals seeking mental health services or substance use disorder services is actually cost. I think that puts us in a funny spot, don't you think?
Yeah, it's sort of, you can't really win either way. Like, the increased cost on the employers for complying is being cited as an argument against their ability to provide access, but access and the inherent cost of accessing those services is one of the big barriers for a lot of people to actually get the mental health care that they need, which, mental health care can really impact literally every aspect of your life, your job, your personal life, your effectiveness at both sides of that coin. It's kind of the inherent tension of employee benefits in general. It costs money to provide benefits. It costs money to comply. The more money you have to spend on the one, the harder it is, the more expensive it is to spend more money on the other.
Yeah, it makes it pretty tough. So let's talk about actually the mental health parity leading up to the 2024 rules. So originally in 1996, amended in 2008, and essentially the Mental Health Parity Act is what is mandating plans that are offering mental health services and substance use disorder benefits to offer them in parity with medical and surgical benefits. When it comes to financial considerations, what the treatment limitations or frequency limitations might be, so that everything is being offered in parity. And then we saw that the 2024 rules that had been issued by HHS are actually trying to strengthen the enforcement efforts and require some increased transparency in what it is that is required. And compounded on that, it's the Consolidated Appropriations Act, lots of acronyms here, the CAA, that added this nuanced requirement for every plan to have a comparative analysis. And that was intended to be a written analysis that is outlining all of the NQTLs that were provided for under that particular plan to demonstrate that they were being offered in parity, not only in practice and operation, but also in writing, and how the plan was being administered and how benefits were being structured. So you want to talk about more specifically, Nick, what was effective in the beginning of 2025 and what's supposed to go into effect in 2026?
Yeah, so the final rule did a lot of things that were in a way kind of helpful to us working on these comparative analyses and, evaluating the NQTLs that plans have in place. Essentially, it made clear that, it requires a written list of the NQTLs that have to be provided to the plan fiduciary. It set specific content requirements for the comparative analysis, so we had a clear idea of what actually needed to go into that written report. And it required a fiduciary certification that the analysis was actually conducted and that the analysis was, compliant and actually fulfilled the requirements under the law. And then plans had to account for any changes that they made to their mental health and substance use disorder benefits kind of in reaction to those assessments. And then going into 2026, it sort of expanded the requirements that plans would have to deal with. Effectively, it was not going to be enough that the benefits be in parity. The benefits had to be literally meaningful, which could kind of push plans into having to provide deeper or more thorough mental health benefits. It also would prohibit relying on anything that wasn't an objective standard. Plans couldn't rely on the vibes of their mental health benefits. And then it would require more data collection, looking at actual effectiveness of the changes to the plans to identify actual material differences that participants saw in their access to mental health and substance use disorder benefits over the medical and surgical side of their plans.
A lot for plans to consider, for sure, when it comes to what needs to be done and documented and written and complied with. So if we were trying to sum all of this up for plan sponsors and those who are helping them to design benefits on an ongoing basis, what do we need to know if we're talking about our takeaways for, as of right now, in the beginning of 2025, as this looms in the background, something for us to consider with this additional report that's been released to Congress about the mental health parity utilization and access? What do we need to remind plan sponsors to do? What do they need to do right now with respect to these rules?
I would say that right now, it's important to remember that this case, while it does have significant potential, and we will be watching it very closely because we are very eager to see how the courts ultimately decide a lot of these issues. I could absolutely see this case making its way all the way up to the Supreme Court, honestly. But I think the most important thing to remember is that this lawsuit is still in the very earliest of stages. So far, it's just the complaint from Eric. I think that the HHS might need a minute for its new administrator to get confirmed by the Senate before it can respond. But the departments essentially have to respond within 60 days from the date of the complaint. So sometime in March, we should see their response. In the meantime, the final rules are, still the law of the land. The final rules are what plans have to comply with, which means plans still have to do their comparative analysis. The comparative analysis still has to meet the standards outlined in the new final rules. And currently, you still have the same burden of compliance that you would have had this case not been filed. So I would say don't do anything drastic just yet in response. But if groups out there do have any questions about the current state of the mental health parity rules or any of the requirements under the CAA to have their comparative analysis performed, that's what we're here for at the FIA group. So we can definitely help answer any questions. We can help guide you through the comparative analysis process. And in the meantime, we'll be keeping an eye on this case to see how this case gets treated without Chevron deference. And we'll kind of get to see an early framework for how regulatory action is going to be challenged now.
Yeah, thanks, Nick. And I think you're absolutely right. I think that this case, intentionally or unintentionally, has the opportunity to have a lot of influence about how future regulatory actions, how mental health parity is going to be enforced, and a lot of different pieces. So certainly something that I know that you'll be paying attention to. So on behalf of myself and Nick, thank you so much for listening to another episode of our Empowering Plans podcast.